Good morning, everyone, to today's webinar organized by Chandigarh Judicial Academy in collaboration with SCC Online. I welcome you all to today's session. The session is on interpreting Jamabandi entries by Mr. B.M. Lal sir, who's a faculty member at Chandigarh Judicial Academy. It is the housekeeping things of this webinar is very simple. Like we've been attending this webinar from a long time. First, Lal sir would detail the entire session on the topic, and post which I would request the members can pose the questions later on, because most of the questions would already will be answered during the detailing of by BM Lal sir. So my name is Chetan Singh Gill, and I'll be the host and the moderator for this session. Without any further ado, I would request Mr. B.M. Lal sir to please start the session and grace us with the wisdom that you want to share, sir. Sir, please, sir.
I start. All right. Good morning, everybody. Now, in this session, I shall be dealing with one basic Jamabandi only. The other specific Jamabandis, which are more complicated, we'll try to deal with in some other session. Now, Jamabandi, as all of you know, is part of the record of rights which is mentioned in section 31 of the Punjab Land Revenue Act. Jamabandi, in fact, is one record of rights. There are other records of rights also, in addition to the Jamabandi. For example, Vazible Arz is also a record of rights. Field map is a record of rights. And Shajara Nasab is also a record of right. Vazible Arz is a village specific. It contains the statement of customs respecting the rights and liabilities in the estate. For example, what right the people have in the common lands, or in the grazing rights in the common lands, or wells, etc. These are customary rights peculiar to every revenue estate, which are mentioned in the Vazible Arz. Field map, as you know, is the map of the entire village. That is, it's about its fields and also the badas, etc. The field map is known by various names. It is sometimes called a Musavi, or Raksh Sajra, or Shajara Kishtwar. These are all different names of a field map. And then Shajara Nasab is the pedigree table, or the genealogical table, or Kursi Nama. Now, the importance of these record of right document is that presumption of truth attaches to these documents under section 44 of the Land Revenue Act. That is a presumption of law. Section 44 says, shall presume. Court shall presume that these entries are correct. It's not that these presumptions are conclusive. The court will only raise a presumption. That means the burden would shift. Then if somebody says this entry is wrong, the burden will shift to the person who alleges that. That is the only purpose of this presumption. And the other revenue records, for example, mutations, khasra girdavris, even patwaris, roznamchas, etc. No presumption of truth attaches under section 44. But still, those are public documents maintained by the public officers. So they can be presumed to be correct under section 114 of the Evidence Act. That would be a case of presumption of fact, because 44 is a presumption of law. This presumption has to arise, but 114 presumption depends. You can presume in a fit case. Now coming back to Jamabandi. Now Jamabandi tells us who are the owners of the various properties, khasra numbers, who are in cultivation, and what is the extent of rights of each person mentioned in the column. and also whether any rent is being paid, and what are the revenue, etc., payable on that property. And then there's the remarks column also. If there is any change in the rights before intervening the two Jamabandis. So one Jamabandi prepared, there is some change of rights, some mutations have been sanctioned. Those will be mentioned in column number 12. And then the new Jamabandi, which would be prepared later on, these entries would be come in the relevant column. Now I have one basic Jamabandi before you. We shall deal with this Jamabandi column by column and try to explain what does it mean. Now you would see, I think you're seeing this Jamabandi before you. There are 12 columns in this Jamabandi. These 12 columns in Punjab now, after computerization, these 12 columns have been reduced to 8. In Haryana, of course, they have retained these 12 columns. But reduction in columns in Punjab does not mean that they have omitted these columns altogether and that this information has been eliminated. No. By reducing the columns, they have not eliminated any information that is provided by the Jamabandi. They have only merged certain columns with the others. Now here you would in Punjab, column number 3, 10 and 11. 3 is Taraf and Patti, 10 is Bash Ka Dhang, and 11 is Mal or Savai. These 3 columns have been added to column 1. This is how 3 columns are reduced. The column number 9 has been added to column number 2. So this is how they have reduced the numbers of the columns, but otherwise the information that is provided in the Jamabandi remains the same, which was in 12. So we shall basically we'll talk about these 12 columns one by one. Now column 1 is Kevat number. Now in this you see 37 is the Kevat number. Now the first question is, what do we mean by a Kevat number? We must remember that Kevat number is not the number of the land. Sometimes people confuse Kevat number with the number of the land. They think that Kevat number is the number of the land, Khatani is also number of the land, and then Khasra is also number of the land. That is not correct. In fact, the number of the land is only Khasra number. Kevat number is a number that is assigned to the entity which owns the land. For example, in this case, you see Kevat number 37. Now this Kevat number 37 relates to the persons mentioned in column number 4. 4 is Malik Vivran Sahit. That is the name of the owner with the description. So 37 is the number given to the owners which are mentioned in column 4. Now this Kevat number is not permanent. It changes with each Jamabandi. Because for example, in the year 71, there are 100 land owning entities in a village. So the Kevat numbers will be 1 to 100. But say in the next Jamabandi after 5 years, the owners have increased and they have 120 or 130. So the Kevat numbers will change. So Kevat number, you can never identify land with reference to a Kevat number. If you have to identify land with reference to the Kevat number, then you must also know the year of the Jamabandi in which that Kevat occurs. Otherwise, it will lead to error, because I have seen a case in which in the year 1960 some land was sold, and it was mentioned land comprised in Khevat number 20, say Khatoni 40, and Khasra number so and so. And then a civil suit was filed in relation to that land in the year 2000. And in the plaintiff said, I am owner of the land mentioned in Khevat number now say 84 and Khatoni number 120, and Khevat numbers of course were the same. And then he, to sustain his claim, he placed on record the sale deed by which he purchased the property. Now an argument was raised by the defendant in that case that this is not the same land, because in the sale deed the Khasa number mentioned is 20 or something, and now in the suit he's claiming land which is in Khevat number 80. So that in fact was not the correct argument, because the answer to that was that the Khevat number would change with every Jamabandi. So we have to identify land not with reference to the Khevat number, but with reference to the Khasra number, which is mentioned in column 7. So Khevat number 37 here is the number which is given to the owners mentioned in column 4. And the shares of the owners are mentioned in column 4. Now, for example, in this case, let us see here Kartar Singh, Dildar Singh, sons of Darshan Singh, Pisar, Fauja Singh. Now, Pisar also means son, because in Urdu, in fact, in Jamabandis, normally I have seen Pisar is used before the grandfather. They would say Puttar or then Pisar Fauja Singh. Bahissa Barabar, 1/2 Hissa. Now, all these two sons, these two brothers now, sons of Darshan Singh, they have Bahissa Barabar. Their shares are equal in what? In 1.5 share. So 1.5 share belongs to these two brothers jointly in equal shares. Now, when we come to the other half, that belongs to these 3 girls, Sukhdev Kaur, Nirmal Kaur, Chand Kaur. They are daughters of Pritam Singh, Pisar Fauja Singh again. In fact, and they have one Bahissa Barabar in the other half share. So in other words, Kartar would have 1/4 share in the entire Khevat. Dildar also shall have 1/4 share in the entire Khevat. And Sukhdev Kaur would have 1/6 share in the Khevat. Nirmal Kaur and Chand Kaur also shall have 1/6 share in this Khevat. So we can find out their share by dividing the Mizan Khevat with this figure. Mizan Khevat means the total area of the land comprised in the Khevat at that particular time. So if the Mizan Khevat is say 80 canal, Kartar Singh would have 20 canal, Dildar will have 20 canal, and then Sukhdev Kaur will have 1/3 of that 80 canal. So this is how we can work out the shares of each person. So this is Khevat and column 4, 1 and 4. These are just basic things I'm telling. The more complicated and other things we'll deal with in the other session. Now I come to column number 2. Column number 2 is Khatoni number. Now Khatoni number is not the number, as I already told you, of the land, nor is it the number which is assigned to a land owning entity, but this is a number which is assigned to a land cultivating entity or land possessing entity. Khatoni has reference to possession. It has no reference to ownership. I give an example. Supposing I am the owner of 10 khasra numbers, I may not cultivate all those khasra numbers myself. So what for example, what I do is that 2 khasra numbers out of 10, I keep to myself. That is, keep on cultivating 2 khasra numbers. And the remaining 8 khasra numbers I give to different tenants. So for example, 2 to tenant A, B and C, 2 each to A, B, C and D. So I have 4 tenants and 2 khasra numbers I am cultivating. This would mean that in one ownership entity, that is keyword number 37, I have created 5 different cultivating entities. In one keyword, I have created 5 khathanis. A person mentioned in the khathani indicates the person who is in possession of that khathani. He can be the owner. He can be a hissedar. He can be a tenant. He can be even a trespasser. But whosoever is in possession of a portion of the land contained in a keyword would have his separate khathani. That would indicate his possession. Now let us see in this case. First khathani is 57. थोड़ा जो ऊपर करना है. बस. That's now the first khathani is 57. Now in this khathani, you'll see line underneath. So this khathani is up to this place, and this line now continues here. Though I've done it with hand slightly gone up, but this land should be here, and then this travels till the end of column 9. What does it mean? That column number 57, the khathani 57, there are 2 khasra numbers in khathani 57. Khasra number 366, which is measuring 0 canal 15 marla. And description of this is gair mumkin makan. And then the other khasra number is 465/2. This is 0 canal 2 marla. This is gair mumkin rudi. These are 2 kitte, means 2 numbers fields, and total is 0 canal 17 marlas gair mumkin. Now what is gair mumkin makan first? Gair mumkin makan does not mean that the house is not habitable. Gair mumkin makan, because the Jamabandi is prepared with reference to the agricultural land. So once we say gair mumkin makan, that only means that the land on which the house is constructed is not capable of cultivation. The land is gair mumkin, that the land cannot be cultivated. Reason is the house. So gair mumkin makan means that on this khasra number 366, which is 15 marlas land, a house has been constructed, and therefore the land underneath the house is gair mumkin. It is uncultivable. This is the meaning of gair mumkin. Similarly, the second khasra number 465/2, we see gair mumkin rudi. Rudi is a manure pit where the manure is prepared. This is 2 marlas. So this again is gair mumkin rudi, because the land is not cultivated because of the rudi. Now the total of these two in this khathani is 2 fields or 2 khasra number. Total area is 0 canal 17 marla, and the entire khathani is gair mumkin. Nothing is being cultivated, house and rudi. And for this, the possession, if we want to know as to who is in possession of these 2 khasra numbers, we have to go to column 5. We see Makbuza Malik. That means all the owners are in joint possession of these 2 khasra numbers. And who are all the owners? Both the brothers and these 3 sisters also. I mean, all these 5 persons, they are in possession jointly in these 2 khasra numbers. That is in joint possession of the entire ownership body. Now you would have also noticed that when the owners are in possession, sometimes it is written khud kasht. So a question arises, is there any difference between Makbuza Malik and khud kasht? Because Makbuza Malik also means the owners are in possession, and khud kasht also means the owners are in possession, but still there is a difference. Now here the difference is khud kasht is used with reference to the cultivable property. Khud kasht means which is being cultivated by the owner himself. But a house obviously is not being cultivated. Therefore, whenever they refer to property which is not being cultivated, they would use the word Makbuza Malik. And where the land is being cultivated, they would say khud kasht. Now, sometimes you would also see in some of the khatanis, there is Makbuza Malik wa khud kasht. So that would only mean that that khatani has both types of land. There are cultivable khasana numbers also and the other ones also. So then they would say Makbuza Malik wa khud kasht. So this is explains khatani number 57. Now we go to khatani 58. Khatani 58 is these are the khasana numbers. इसको थोड़ा ऊपर करना. There are the khasana numbers 58. थोड़ा yes. Now khatani 58. You would see there are 7 fields in this khasana number in this khatani. 5 mustil 20, 5 mustil 21, 27 mustil 11, 12, 17, 6 mustil 15 min, 16 min, and then the area is mentioned, then the type of land, that is chahi. Chahi means this is being irrigated through tube well. So these are total is 38 canal, 18 marlas. Now this land is cultivable, chahi, and this is in possession of one Kartar Singh Hissedar. This is in possession of one kosher. His name is Kartar Singh. So he is in cultivating 38 canal, 18 marla, 7. Now here one thing I wish to explain. You would see that in Khatani 757, the khasa numbers are, there are no double lines, there are no mustil. This is simply 366 and 465 or 2. But in Khatani 58, you would see that there are mustils, 5 mustil 20, 21, then 27 mustil 11, 12, 17. The reason is that the land in Khatani 57 is not cultivable for mustil land. This is inside the Firni and outside the Lal Lakir. To understand a village, you have to keep in mind 3 things basically. First is the Abadi. Abadi is the Lal Lakir. The limits of the Abadi is the Lal Lakir. Now in the Jamabandi, the entire Abadi is given one khasra number. That's all. Inside the Abadi, various people are in possession of various portions, but those divisions are not shown in the Jamabandi. They are not given any separate khasra numbers. Abadi, the ownership of the Abadi is shown as Abadi De. That means the people living in the Abadi, they are the owners. And one khasra number is given, that is the end of the matter. Inside the Abadi, if you wish to find out who's the owner, Jamabandi is of no help. For that, you will have to look to evidence, some other evidence of possession, or because presumption of ownership can also be drawn from possession under Section 110 Evidence Act. But Jamabandi is of no help to ascertain or to find out as to who is the owner of some property inside the Abadi. So outside the Lal Lakir and inside the Firni, because outside the Lal Lakir there is a Firni, and in this area between the Firni and the Lal Lakir, this is also divided into Badas. But this is not cultivable, so there are no mustils. Only Badas are drawn and numbers are given, and those numbers are direct numbers 366, 465, 2 means they are divided into 2 parts, and these are not very large area numbers, 10 marlas or 15 marlas or something like this. So that is why there are no mustil numbers we find in 57, but in 58 we find all the mustil. Now a mustatil is a literally mustil is a Urdu word which means a rectangle, and murabba is a square. Though in common parlance, the revenue officers or the people dealing with Jamabandi, they also loosely refer to a mustil as murabba. So they some revenue officer might say 5 murabbe ka khasra number 20, but that doesn't mean it is a murabba. It is where it is a mustil, it is a mustil. Where it is a murabba, it is a murabba. Now, how to find out whether it is a mustil or a murabba? That would be another question, because the double line would depict both. From the double line, you cannot say it is a mustil. It can be a mustil. It can also be a murabba. Double line indicates both. But how to find that out? Because whether it is a mustil or a murabba, would you can find out only from the field map. Field map will tell you whether they are squares or they are rectangles, because a rectangle is 200 karam into 180 karam. The measurement of a karam is east to west. The measurement of one karam, one mustil is east to west 200 karams. A mustil is 200 karam from east to west, and from north to south, mustil is 180 karam. That is what 200 into 180. So therefore, each field is Chali Chatti, as they say, 40 karam by 36 karam, because a mustil is then divided into 25 fields. Chali into Chatti, 40 karam by 36 karam. Another thing which needs to be remembered here is that in the case of a mustatil, the karam that is used is only 66-inch karam. There are different sizes of karams. But in the case of a mustatil, the only karam that is used is 66 inches. And when this karam 66 inches is used, the areas would be in canal marlas. That is important. In villages, because every village map will on the top tell you which karam is being used in the village. So if it is 66 inches karam, that you should immediately find out that the area is in canal marla. The other commonly used karams are 57.157 inch, where the karam is 57.157 inch. In those villages, the areas would be in Bigha Biswa. If you find in a village map that at the right hand top corner, if it says karam 57.157 inch, that means the village area would be in Bigha Biswa. These are the normal Bigha Biswa. Sometimes in some villages you will find karam is 99 inches, where the karam used is 99 inches. That's quite rare. In Ludhiana, I have seen karam 99. In Faridabad, in Haryana, I have seen 99. So when 99 karam is used, then the area would be in Pakka Bigha Biswa. There is a distinction between a normal Bigha and a Pakka. Pakka Bigha Biswa is sometimes called a Shah Jahani Bigha. Now the Pakka Bigha is 3 times bigger than a Kacha Bigha. So if one even Bigha Biswa, one has to be careful whether it is a 57-inch karam or 99 inch. Again, one must before in fact we try to ascertain rights with reference to the Jamabandi. and then there is a question of area and other things involved. I think it would be profitable to also take a look at the village map, because that will tell you so many things. The karam used, whether it is a square, marabba, or a mustil, these things are relevant. And another thing you have to keep in mind, that in the case of a mustil, no other karam is used, only 66 inches. But in the case of a marabba, all the three karams are used. Marabba is 200 by 200. 200 karam from east to west, and north to south also 200 karam. Here the karam can be any length. It can be 57.157. It can be 66. It can be 99. If in a marabba layout, 57.157 karam is used, the area would be in Biga Biswas. If 66 inches karam is used, the area would be in Kanar Marla. If in 99 is in used, then the area would be in Pakka Biga Biswas. So these are the three commonly used karam lengths, though there are other karam lengths also which are in vogue in some parts of the state. For example, 54, 60 inch also, those are, but those are Gomao areas. But today I will not deal with those. That will, now we'll proceed further in this case. Now the Jamabandi which you have before you, you will assume that this is a Mustatil Jamabandi. Here the karam is 66 inches and the field is and the karam, I mean the mustil is 200 karam into 180 karam, and each field is normally 40 into 36, that is maximum 8 canal. If you multiply 40 karams by 36 karams, the area would be 1440 square karam, and it will work out to 8 canal. The fields can be lesser, I mean the area can be lesser also, because sometimes there is a passages are provided in the fields, raste, and sometimes the otherwise the area is less because the corner plots they can have lesser areas. Now we come to this Kartar Singh Hissar. Yes, now we see there are two Khasra numbers which are referred to as min. 6 mustil, 15 min, and 16 min. Now what does this min means? Min literally means a portion, a part, tukda, a part or portion of a particular khasra. So 16 over 15 min, 1 canal, 2 marlas mean it is part of khasra number 15. Similarly, 16 min means 40. It is also part of khasra number 16. But you would also have seen that whenever a khasra number is divided, say in two parts, then they mention it as 15 over 1 and 15 over 2, or 16 over 1 and 16 over 2. That you must have seen in so many cases. But why in this case they have used the word min instead of 15 number over 1 or 15 over 2? So this is an important distinction which you have to understand and keep in mind to avoid confusion. Now, min is a division of khasra number, all right, but it is not the division of ownership. It is a division of possession. Now, this one is now supposing khasra number 15, 6 over 15 is 8 canal. Now, it is not necessary that one co-sharer cultivates the entire khasra number. He might cultivate a part of it, and the other part may be cultivated by somebody else. Now there the ownership remains intact. Khasra number 15 is owned by all the proprietary body mentioned in column 4. The only division of the khasra is with reference to the possession. So therefore, since it is only, it's not a field has not been divided in so far as ownership is concerned. So it is not 15 over 1, 15 over 2. If it is partitioned and divided ownership, then obviously it would be 15 over 1 and 15 over 2. Here it is only a possession, division for the purpose of possession. So therefore it would, these two mins indicate that. And for this reason also, the other mins of this these khasra numbers will be in some other Khatani. They cannot be, both the means cannot be in one Khatani, because if both the means are in one Khatani, then they will become the whole Khasra number again. Then why min? So now you just note down these two. 6 we'll see, because these we'll see in the other Khatani. You will find the other portions. 15 min 1 2 you can write. 6 mustil 15 min 1 2, and 6 mustil 16 min 4 0. This you can take a note of. And we also see that Kartar Singh is now cultivating these 38 canal 18 month. Now we move to page 2. Page 2. Next page. Yeah, page 2. Now page 2 is see the Khasran, this 37 Khavat continues. So that is 37 Mazkur. Mazkur means continued. Actually, technically, Mazkur would mean, because this is again Zikr. This is derived from Zikr. Mazkur means the jiska Zikr upar ho chuka hai. Mazkur. So it is aforementioned. It in a context it will can mean continued. So 37 continued, because the page this next page. So Khavat number they say 37 continued, and 4 also says Kartar Singh Adi Maskuran. This also is in continuation. So they are not, instead of writing all the names again, they simply say Kartar Singh Adi Maskuran mentioned above. Now we move on to this third Khatani, that is Khatani 59. Now immediately you'll see this is in possession of Dildar Singh Hissedar. That is the second person you mentioned in column 4. Now Dildar Singh is cultivating these 5 Khasra numbers. And first you will notice 16 15 min 16 min. Now 15 min 1 2 was in the possession of Kartar. The remaining 16 18 is in possession of Dildar. So this is also a min. And 16 min 40, 140 portion is cultivated by Kartar, and the second 40 is cultivated by Dildar. So in this manner, Dildar is, you see, 5 kitta. He is in cultivating possession of 5 kittas. Total is 13 4 10. Now we come to 60. 60 is thoda upar karna, Aman. Now 60 you would see there is only one Khasra number, thoda bus. Khasra number 60 you would see there is only one Khasra number. 26 mustil 20, 5 canal 12 marla chahi. Now this is an important entry. This is known as Khana Kasht entry, or a Khana Kasht sale. This is a very important thing to be kept in mind. Now this entry carefully we read 5. Dildar Singh Hissedar Baya. Baya means seller. That means Dildar Singh, who is one of the co-sharers, has sold this Khasra number. This means this. And Ruldu Puttar Makhan Mushtri. Mushtri means purchaser. Kasht Mushtri. Now what does it mean? This Khasra number 26 over 20, which measures 5 canal 12 marla, it has been sold by one co-sharer, Dildar Singh, to Makhan Singh, to Ruldu Singh, and Ruldu is in possession of this, cultivating this Khasra. Now, this is this entry. Now, despite the sale, Ruldu's name does not appear in column 4. Even though he has purchased it, his name does not appear in the column of ownership. His name only appears in the column of possession. So these are called Khana Kasht sales. Why these are resorted to, and what are these legal implications, I'll just explain. Now, the normal rule is that a co-sharer cannot sell a specific Khasra number in the joint holding. This is the normal rule. He can only sell his undivided share or a fraction of his share. And if he does that, the name of the vendee will come in column 4. If he sells his entire, say, Dildar sells his entire 1/4 undivided share, then the name of the purchaser will come in column 4 and the name of Dildar Singh would be omitted. But in this case, um, since Dildar Singh cannot sell a specific khasra number in the joint khabat, therefore he cannot confer any indefeasible title of this khasra number upon the vendee. So therefore the vendee's name cannot come there. It will depend on partition. Now in a now in a khana car sale, what is permitted is that where a co-sharer is in exclusive possession of a particular khasra number, and that exclusive possession is evidenced by a revenue record, then he can sell that khasra number to a particular person without that sale is only of possession. That does not transfer the title in that khasra number in favor of the vendee. The vendee can only he becomes entitled to take possession of that khasra number, and the sale would be relatable to undivided share of Dildar Singh. As to what property he gets and where he gets would depend upon the partition. When the partition of this khabat takes place, out of the share of Dildar Singh, Ruldu would be given some property. And this is not necessarily 26/20. He can go anywhere. And that will also depend upon the extent of right of Dildar Singh. Now, supposing Dildar Singh has already sold more than his share in the property, and then he is in possession of more than his share, and he again sells, say, 5/12 to Ruldu, then on partition, Ruldu may not get anything. So this sale is in a fluid state. For this, I would like you to note down one judgment by the Honorable Punjab High Court. That is by a 5-judge bench. That is Ramchandar versus Bhim Singh. Ramchandar versus Bhim Singh and others. This is by 5 judges of Honorable Punjab and Haryana High Court. The citation is 2008, Volume 3, Punjab Law Reporter 747. I would repeat, 2008, Volume 3, Punjab Law Reporter 747. This is by 5 judges, and the author of the judgment is Honorable Justice Bhalla. And paragraph 19 of this judgment is the relevant portion on this point. I'll read para 19, which deals with khana car sale. Another attribute of joint property is that where a co-owner in possession of a specific portion of the joint holding, where a co-owner in possession of a specific portion of the joint holding and recorded as such in the revenue record. So this should also be recorded in the revenue records. And it's not that somebody says I'm actually in possession of some specific portion I've sold. No, he has to be recorded as such in the revenue record. Then from his portion, from the portion in his specific possession and recorded as such in the revenue record, he can transfer right, title or interest from the portion in his specific possession, but his vendee would be entitled to protect the portion so transferred without asserting exclusive ownership to the portion so transferred and possessed till such time as the property is not partitioned. So this right is not as yet crystallized. I mean, he cannot lay claim to 26/20, and he may not even be able to lay claim to any specific share in the joint holding, keeping in view the area which he has purchased, because that would depend upon the share that is left with his vendor, because it is also common knowledge that sometimes a co-sharer is in possession of much more than his share. So in such a situation, so this is a khana car sale, and that is why the name of the vendor is retained in the Jamabandi. If he sells his share, undivided share and his name goes to column 4. The vendor's name is not mentioned, but here the vendor's name is retained, so that when partition takes place, you know this person has to get from the share from whom. Now we come to Khatani 61. Now Khatani 61 is Kulwant Singh Puttar Mohan Pisar Ganga Gair Marusi. Now he is described as Gair Marusi, and Khasra number is mentioned, and Batai Nisaf is mentioned in column 9. Now the question is asked normally, what does a Gair Marusi mean? Gair Marusi, and the common answer that I got from the students here is Gair Marusi is the tenant. Well, that answer may not be absolutely correct. Gair Marusi can be a tenant at will, there's no doubt on it. But Gair Marusi, description of a person as Gair Marusi, does not necessarily mean that he is a tenant. Gair Marusi can mean a variety of things. The only way to understand is Gair Marusi, when somebody is described as Gair Marusi, firstly you can say he is not the owner. He is the Gair Marusi, so he cannot be the owner. He is not a mortgagee because mortgagee is Murtahin. But he can be a tenant, yes. At the same time, he can be a licensee also, or he can even be in an unauthorized occupation. So Gair Marusi can mean a variety of things. Whether he is a tenant or not will depend upon column 9, that is the rent column. If he is under a liability to pay rent, then he would be a tenant. For example, in this case, Kulwant Singh is a Gair Marusi, but in column 9 it is Batai Nisaf. Batai Nisaf means that he is under a liability to pay, to give half of the produce to the owner. So therefore he is paying rent. Rent can be paid in cash or kind. So therefore this person in this case is a tenant. A judgment on this point I would like to give you. The 1980 PLJ pages 295 on this point, judgment of the Punjab High Court. 1980 PLJ pages 295. This is Ram Karan versus Financial Commissioner. Now in this judgment it is clearly said it is settled law that generally in the revenue record, persons even in unauthorized possession are described as Gair Marusi. But from this entry alone, it cannot be held that the status of such person is that of a tenant, unless in the rent column it is disclosed that such persons are liable to pay rent. So that is the liability to pay rent is the sine qua non of the relationship of landlord and tenant. You cannot think of a tenant relationship landlord tenant unless there is liability to pay rent. Liability to pay rent is a must. Now here one thing more I'd like to just Aman, I just briefly Nietzsche. I'll just briefly deal with some other columns. Column 3, column 10 and 11. Now column 3 is Patti and Taraf, 10 is Bash and 11 is Mal. Now Patti and Taraf actually these days it has lost. In fact, all these 3 columns today are bereft of any significance. Because Patti actually or Taraf, they are the division of a village community on the basis sometimes of consanguinity, I mean the relations, and so people who are related to each other through a common ancestor. Consanguinity is the call. And they may be, Patti may be comprising of one caste, so Patti Brahmana, they can be a Patti Brahmana, say Patti Saniya, or sometimes they can also be based on religion, etc. So the whole idea of this division, normally these people, when these Pattis and Tarafs were formed, they were living in one part separately in one part of the village. But nowadays there is no such hard and fast distinction. They can be living anywhere. But a patti would be mean a person belonging to a particular community, particular caste, or a particular relationship. And the whole idea behind these pattis, why were these created? Was because for each patti they had a different lambardar. The whole this was in fact intended to facilitate revenue collection. For example, there is a patti brahmana. That means the Brahmin community is in one patti, and they will have their own Brahmin lambardar. So it will be easier for him to collect his revenue from his patti persons and deposit in the treasury. So that is why in column 3 sometimes they mention only the name of the lambardar. That means the lambardar who is in that patti. And Bach is the Bach means how the land revenue is distributed in the village. I mean, what is the scale on which it is distributed, method of distribution, who will pay how much on what formula. And 11 is the actual land revenue payable and the cesses, that is Mal and Savai. Now in Haryana, this land revenue has been altogether abolished. So 11 not relevant at all. And in Punjab, it has been suspended. It is not being collected anymore. The only relevance in Punjab for this revenue column is to work out the court fee payable, because we know that in agricultural land suits for possession, the valuation for land revenues for valuation of the land for possession, court fees is 10 times the land revenue, and for ascertaining the jurisdiction, it is 30 times the land revenue. So that is the only relevance it can have. So, all right, now I think you can ask questions.
Certainly, sir. So we have few questions. So shall I ask the question, sir?
Yes, sir.
So, just a sec. Sir, I've taken off your desktop, so only your face is visible now.
Mm-hmm.
So the first question, which you have already addressed in the starting, but I think I'll just raise the question again. How can we conclude that the entries of Jamabandi have been rebutted?
Oh, that would, in fact, that is nothing would appear from the Jamabandi itself. That would depend on the evidence that is led. But as I said, the entry in a Jamabandi is only a presumptive piece of evidence. Supposing somebody says Kartar Singh is recorded as the owner of the Jamabandi, it will presume that Kartar Singh has 1/4 share. But if somebody says no, this is wrong. Actually, when his father died, he had executed a will, and the entire property had been given to one son, Dildar Singh. So therefore, this entry is wrong. So he will have to rebut it by proving the will, as per law in the court, because under section 45 of the Punjab Land Revenue Act, any person who is aggrieved by an entry in the revenue record in Jamabandi, he can file a suit for declaration, claiming a declaration from the civil court that this entry is wrong and this extent of his right is this. Now, for example, as this question, a person, the Dildar Singh says the name of Kartar Singh is wrongly mentioned, but the court will say we'll presume it to be correct. So what will the court do? They will frame the issue by placing the onus on Dildar Singh. It is for the Dildar Singh to rebut the presumption. So Dildar Singh will have to bring on the record that will. He will have to prove that will in accordance with law, and then say that this entry is wrong. Then the court will give him a declaration that the entry is wrong. So rebutting a entry in the Jamabandi would depend upon the other evidence that is available with the party. If no evidence is available, then the presumption, then because of the presumption, the entry would be taken as true. So that is.
So a related question from Gurdaspur CJM sir. He's asking that what is the importance of entries, Lambardar and Patti?
This, in fact, I made a brief reference. As I said, that Patti, division of villages into Pattis, with reference to, with the view to facilitate actually the collection of land revenue. Because when the Britishers made this Punjab Land Revenue Act was passed and Jamabandi, etc. was prepared, the basic idea was to prepare a method document to facilitate collection of land revenue. and the person, the officer or the representative of the state who used to collect the land revenue was the lambardar. So when you mention in a particular keyword that this is the lambardar, that indicates that for that keyword, this lambardar will be collecting the revenue, land revenue. That is the purpose of mentioning the lambardar in column 3, which now would come to column 1 in Punjab. And another relevance of Patti was because Patti was, as I said, either consisted of people belonging to the same ancestor or belonging to the same caste or religion. So the person, Lambardar, was appointed from that community. So, so that he could collect the land revenue easily. That was the whole idea. But now this has lost most of, I mean, this is not of much importance now. Now the Lambardar is not collecting the land revenue. He is only identifying people in the court.
Yes, I know.
Yeah.
The entire thing has changed now, and I think that's so good.
Yeah.
So another sub part of this question, we talked about Pati, we talked about Lambadar entries and everything. The question is now about Murabba. What is the importance of entries of Murabba?
As I already told you, Murabba means literally a square. When we say that a field is in a particular Murabba, that means that field is in a particular square, or just 4 Murabba. For example, somebody say, Mera khet 4, Murabba number 4 mein 25 number hai. So if in the field map, we'll find out where is Murabba 4 and his field would be located 25. But as I already told you, Murabba is a term which is being loosely used. People are using, people are also referring to a mustil as a Murabba. So when somebody says that my khet is in mera khet frane Murabbe mein hai, that does not necessarily mean a square. It can be in a mustil also. So whether it is a Murabba or a mustil, we'll have to find out from the field map. Yes. Next.
So the next question is, I think it seems like an incomplete question. I think I still read it. It says A enters into an agreement to sell with B. However, later on he receives the remaining part of the consideration and executes power of attorney, thereby giving the possession and all the other ancestry rights to B. As no sales deed was executed between them, so the entries and revenue record never changed. Thereafter, after 11 years, A revoked the power of attorney.
This question I have to repeat. I have not understood. It's too many facts.
I know. So basically, I'll ask.
If can it be in the written form?
So
or you can move to the other question. We'll keep it.
I'll show it to you in the written form as well, sir. But I'll just move to the next question. The next question is from Civil Judge Jalandhar, sir. On what basis a co-owner in a joint property can be recorded to be a possession of specific khasra number, and whether his ownership right is different from the co-ownership rights?
I'll explain. A co-owner who's in exclusive possession, firstly, whatever rights he has, are flow from his co-ownership right only. Only when it is in a specific possession of a particular khasra number that he has a limited right of sale of the possession. Now the question is, I think what the learned judge wants to ask me is this: how a person would be recorded as an exclusive possession of a particular khasra number? That I think is the first part of the question. How is he recorded as in specific exclusive possession of a specific khasra number? I think that was the question.
That is the first question, sir. Yes, sir. That is the first question.
That is the question. Now here you would see that the column 5 entries are taken from khasra girdavaris. Now whatever the entries in possession are in the Jamabandi for a particular year, in the next Jamabandi, the latest Girdavari entries of possession would get incorporated in the Jamabandi. And if there in a particular Girdavari you find that a particular co-owner is in exclusive possession of a different specific khasra number, he would be allotted a different khatani in that Jamabandi. Now another question is how are Khasra Girdavari's entries are made. That is a separate question altogether. That I will deal with in some other lecture on Khasra Girdavari. But here you can take it like this. That these Khatanis are I mean, renewed or relayed as per the latest Khasra Girdavari entries.
So, moving to the next question, sir. The question is, what is the yardstick for clustering estate holders in a Khevat? And can a particular estate holder surface more than one Khevat?
Once again, not very clear.
So, what is a yardstick?
Mhm.
The yardstick for clustering estate holders
Classic,
in clustering estate holders. So,
classifying, I'm not, what is
the
the word?
clustering, combining together.
Acha, together.
Yeah.
Acha, yes,
So, yeah,
yes.
what is the yardstick for clustering estate holders in a Khevat? And can a particular estate holder surface more than one Khevat?
Now let us see. Joint ownership, I mean, different people are classed in one keyword depending on various circumstances. Let's take a few illustrations.
Sure.
Supposing one Fauja Singh is the sole owner of a particular keyword at one particular time. He dies, he has two sons, he has three daughters, as you see, he has a wife. So, as under section 8 inheritance, mutation would be sanctioned. So, when in the new keyword would be in the new Jamabandi, one keyboard, all these 5 persons would be 6 persons would be in one keyboard. So, and another question, I mean, example, supposing four brothers purchase a property jointly from one person. So when their name appears in the Jamabandi after mutation, all those first 4 persons would be in one keyboard. So, so there's a variety of ways in which different people come in a particular keyboard. And four brothers, I mean, they purchase and then one of them sells the property, one his undivided share. The Wendy would also come. One brother dies, his heirs would come. So different people can conglomerate in one cupboard because of different situations. The second question is, can different one person have different cupboards? Yes, he can, because you would see in a cupboard, you can. I mean, the Khasra numbers can move out of a cupboard, but they are not added to a cupboard. So now I'll put it like this. Supposing in my keyword I have three Khasra numbers. I sell one. So the person who purchases my keyword, one Khasra number out, he will move out of the keyword in the other Jamabandi. My keyword will be reduced to 2. So he will have a separate keyword number in the next Jamabandi. But if I purchase a keyword number, if I purchase a Khasra number separately from so I will not, that Khasra number will not be put in my existing keyword. For that, I will be given a fresh keyword number. So that is how one person can have more than, it's just like a bank account. Now I can have 2 accounts, 3 accounts in the same bank. In fact, I personally had one point of time, 3 accounts in State Bank of India, same branch. So it all depends. But now I don't have even one. All right.
Yeah.
Yes.
I think that's a very personal example that you've given to make everyone understand.
Yeah.
But I'll move to the next question, sir, considering
Mhm.
that time is, we don't have a lot of time. So the question is whether the registered sales deed are executed for sale of land situated within the red line.
Yes, why can't we? In law, there is no prohibition in law. I mean, if we talk of our civil law, common law, there is no prohibition against selling land in within the inside the Lal Ki. Though in some cases, the Punjab government has issued some notifications prohibiting the registration of sales. They have they issue sometimes these directions asking their sub-registrars not to register these sale deeds. That is only administratively they issue those notifications. But I personally also think if you can challenge those notifications, I don't think they can do that because under the common law, you have a right to transfer your property. The only question is whether you own it. If you can prove your ownership, the sale is valid. Yes.
I think, sir, the question is already answered because when you said the government can only, stop from registering a deed, the question was the person already had the registered deed.
If he has a registered deed and he wants to sell it further, still he can sell it. But if the government says now no new sale deed would be registered pertaining to the Abadi land, I think that legally may not be correct unless there is some statute is passed. Administratively, it should not be possible. And if somebody does that, it can be challenged in the High Court. File a writ petition and challenge. Yes, it can be satisfied. Quashed, I mean. Yes.
Moving to the next one, sir. It's about Jamabandi in respect to how can an entry with a wrong khasra number in Jamabandi can be corrected?
I mean, if khasra number has been wrongly mentioned.
Yes.
In a Jamabandi. So, as I said, there's section 45 of the Punjab Land Records of the Punjab Land Revenue Act. The first thing, of course, would be if it's just a clerical mistake. This mistake can be clerical, typographical, accidental. In such a situation, one can bring this error to the notice of the Tehsildar or the Revenue Authority, and then they can prepare a fard badar. We call it a fard badar procedure. If it is merely a clerical error, omission or something. So the Revenue Authorities can and prepare a fard badar correction. That is fard badar. Badar itself means correction. And correct the Jamabandi. But if there is a serious dispute between people regarding title or something, then under section 45, one can file a civil suit and seek a declaration.
Exactly. Sir, now again the question about red line, the Lal Lakir. And now the question is whether land falls within Lal Lakir, whether it can be sold mentioning the boundary.
Whether it can be sold?
As mentioning as it a boundary, that it's a boundary.
Oh, I see. Yes. Because once land falls within the Lal Lakir. The first question is what is a Lal Lakir? Let us be clear about the Lal Lakir first. Actually, the Lal Lakir is a outer limit of the residential area of a village as it existed at the time of settlement. So thereafter the Lal Lakir is static, it will not change. People may move out of the Lal Lakir, have the residence, but the Lal Lakir will remain there intact. Now the question is as I already said, Lal Lakir is given one khasra number. I mean, the entire area inside the Lal Lakir, even if it is 13 acre, 20 acre, whatever area, it is given only one khasra number. And what is the division inside the Lal Lakir? That is not depicted in the Jamabandi. So the only your ownership would depend upon the evidence you lead. As I said, since there is no title deed available in for the property inside the Lal Lakir, the only evidence can be that of possession. That is, and presumption of ownership can be raised from possession, 110 Evidence Act. And this is also known in common law as the doctrine of lost grant. If 1110 actually is flows from that doctrine in common law. It is known as doctrine of lost grant. It means that a person who is in possession of a property since long, it shall be presumed that his possession originated in some legitimate grant which has now been lost. So that is known as doctrine of lost grant. This is the common law principle, and it finds, this is the manifestation in 110 of the Evidence Act. So coming back, if you can show that you are in possession of a particular portion in Abadi since long and you can prove your ownership on that basis, then obviously the only method to identify the property would be boundaries and dimensions. Unless it is numbered, if no number is given to a property, the only way to identify is what is towards it, east, west, north, south, and what is the length and breadth of the property. That is the only way. Yes.
So moving to the next now, this is about the land that a lot of people got during the partition of India-Pakistan. So the question is, what would be the evidentiary value of a Jamabandi obtained from Pakistan in respect to the land left there in a partition, and certain correctness of evacuee land allotted in India?
No, insofar as the Jamabandi entries, because whatever you, I mean, you will get record from the Pakistan say it is Jamabandi.
Sure.
Now the Jamabandis, even in Pakistan, they are prepared also under the Punjab Revenue Act 1887. It's not that they are prepared in some other law. So Section 44 will apply to those Jamabandis also. So whatever entries, provided you get the proper certificate copies and certificate and in the proper through a proper channel, then the entries in those Jamabandis also shall be presumed to be correct. And as far as evacuee property is concerned, evacuee properties are actually those properties which are evacuated by the people who migrated from India to Pakistan.
Yes.
So these properties were firstly, then act was passed, then this was given to the custodian general, and then in a package deal, the properties belonging to Punjab were given to the Punjab state, and then these properties were then allotted to various people by the Punjab state through a rehabilitation department, and then they have their sanads and other things. That is the evidence. They will have to prove they have been allotted.
So now talking about the uncultivated land, the question is, how is the possession of uncultivated land given, and how it is entered in Girdabadi?
Uncultivated land, you see, possession is always mentioned as to who is in possession. Cultivation is only deal with khali, or they might say it is Banjar Kadeem or Banjar Jadid. Now, for example, if what do the Jamabandi, I mean, Khasra Girdabri would say? They would first, Khasra Girdabri will lift the possession from the Jamabandi. Now, for example, the Jamabandi is prepared. So the first Girdabri after that Jamabandi would lift the possession entry from the Jamabandi. So that would be deemed to be in possession. The person is shown to be in possession, the Jamabandi. If there is a subsequent change in possession, that will be recorded as per para 9.9 of the Punjab Land Records Manual. There is para 9.9 in the Punjab Land Records Manual, which tells us how can a Patwari change a Khasra Girdabri possession entry. That is a different matter. But here, if there is no, there's no crop sown in a particular field, and the Patwari goes for Girdabri, so he goes for Girdabri twice a year. That is Hadi, Rabi, and Kharif. So Kharif and Rabi, Kharif is October somewhere, and Rabi is April, March, April. So whatever crop is standing in a particular field is recorded by him. And if a particular field is not lying uncultivated, he will only say Khali. In such a case, he might say Jamabandi. For example, this Girdabri can sound like this: Khasran of such and such, owner Ram Singh, cultivator Shyam Singh. Then in the possession column, he will say Khali. Khali means it is lying uncultivated, fallow, F-A-L-L-O-W. And then if in the next time also, he finds that it is not cultivated, he will again say Khali. Third time again he will say Khali. But the fourth time he will not say Khali. Fourth time he will say Banjar Jadid. Banjar Jadid means a recent fallow.
Okay.
Khali is a current fallow. Banjar Jadid is a recent fallow. But then if it continues up to 8, on the 8th occasion, he will call it a Banjar Kadeem. Kadeem means old fallow. Yeah. Fallow means F-A-L-L-O-W, not F-E-L-L-O-W. Yes.
That has been clarified now.
Because I may be an old fellow with F-E-W.
Yeah.
Yes.
So moving to the next question is from Mr. Neeraj Goyal, sir, from Khanna.
Neeraj Goyal from Khanna.
Yes, sir. The question is, a degree for partition has been passed on the basis of Khasra number mentioned in Jamabandi. So degree of partition was passed on the basis of Khasra number mentioned in the Jamabandi. But when the execution was supposed to take place for partition of the spot, the Khasra number was not found in any of the government records. So how can we find the Khasra number? How can we locate it? How can we measure it? And how can we partition at that spot?
Now, this is actually first of all, you say there is a Jamabandi contains a Khasra number, mentions a Khasra number, but when you go to the spot, you don't find that Khasra number.
There's no record. There's no official record, neither in
But
Musafi.
Jamabandi is the official record. It's not
But-
because I'll explain.
So the
Now the
question,
revenue.
one more add to is it's not found in AKS Shajra or any other revenue record like Musavi etc. of Pawat, Patwar or Sarkar.
Aksar Sajra is a field map. I mean, if a Khasra number is not mentioned in the field map, he wants to say it is not mentioned in the field map, but the Khasra number is mentioned in the Jamabandi.
Sure.
And then you have to, I mean, the first thing, but this can be an error. I mean, it's not that everything is dishonest. Sometimes there can be an error also. As I said, if there is an error, it can always be corrected through a, I mean, supposing there is actually no Khasra number. Firstly, I presume that actually there is no such Khasra number. Then obviously the partition decree is meaningless. Obviously, if you have a partition decree pertaining to a non-existent property, execution will also be of non-existent property, so that is of no significance. But how to find out whether it is actually there? I mean, practically. Now, in such a situation, the first thing you should see is the field book.
Okay.
Actually, the field book is a very important document, which I have found that our judges are not using it the way they should be using it. I mean, some of them are not maybe using it properly. Now, field book is a very important document. What is a field book? Now, field book contains the area and the boundaries of every Khasra number in the village. Area and the boundary, the area and its boundary, I mean, its dimensions, not boundary. For example, it is measure 30 karam, 40 karam, 40 karam, 36 karam, like this. So it would mention in the sequence of east, west, south, north. Now, for example, the field book says Khasra number 5 has the dimensions 30, 40, 36, 40. It means east, west, south, north. EWSN. It is in this manner that this mentioned. So then it will also tell its area and it will work out that area arithmetically. It will not just be mentioned 7 canal 12 marla. They will you will find a properly multiplication 36 into 40 over 2 into this, and then the area. So the field book is a very authentic document. It cannot be tampered with because you cannot change the entire equation. You can convert a 3 into a 8, but if you convert 33 into 38, the entire mathematical calculation would change. So if you change a field book, I mean, you can't change it without being noticed. So in such a case where you find there is a Khasra number in the Jamabandi, first of all, you should also you should see the field, I mean the Aksajra or the Musavi, okay, whether it is there or not, and then see if some Khasra number is omitted, because sometimes Musavi or Aksajra also does not mention all the Khasra numbers. Sometimes it is omitted, but then you can find out. Now I can always find out because it moves in a particular, there is a method in which a Musavi is prepared, because it starts from northwest corner, it ends at the southeast corner, and the thing moves spirally. So even if a Khasra number is missed, you can, taking a look at the Aksajra, at least we can find out whether there is such a Khasra number or not. Anyway, first we look at that and then we call for the field book and then see whether Khasra number is there, and it will give all the dimensions and the area. And even if it doesn't solve the question or problem, then we can go back. We can ask the Patwari to show me the prior Jamabandis, prior field maps, everything, say 5-10 field maps and Jamabandis. So we can find out at what stage it got omitted. And sometimes there can be a mistake during consolidation also. I mean, this is a question which can be have a bit. I mean, this problem can arise for a variety of reasons, not one.
Can
So,
have a lot of outcomes depending on the
so
situation.
there can be so many reasons for this problem. But if Mr. Goel can tell me a specific this thing, I can give him the answer. I can solve his problem.
I request Goel sir to probably mention anything related more if he needs to ask. Otherwise,
Yes, he can.
we wait. So I'll move to the next question. The
Yes.
next question has a scenario, but I think a scenario is been listed. It's a big scenario, so I will just ask the main question to you. The question is how to interpret entries of a FAD Jamabandi along with the connected documents related to the consolidation so as to enable the code to ascertain the identity of the numbers are allotted to the number of khasra might be number of khasra allotted to the owner.
No, I understand. In fact, the question is, how do we tally the pre-consolidation with the post-consolidation khasra
Exactly.
number? That is basically, this is the question. Though I am thinking of allocating one full session to the consolidation, because consolidation is a big subject. How the consolidation start, but still I'll answer this question in a nutshell. I will ask the way to find out is this, that pre-consolidation khasa numbers are mentioned in the Khatani Ishtimal. Now there are 4 basic documents in a consolidation, that is Khatani Ishtimal. Then there is a Naksha Haq Darwar. Then there is a Khatani Pamaish. Then there is a Misal Hakiyat. So these are the various documents which are prepared during consolidation. Now what it does is that when the consolidation begins, all the existing rights of the people are taken out from the Jamabandi. They are updated. I mean, consolidation might start say 3 years after a Jamabandi is prepared, 4 years after Jamabandi. So the last Jamabandi is updated. I mean, all those new rights which have accrued are included, and a Khatani Ishtimal is prepared. Now, Khatani Ishtimal will tell us as to what are the Khevat number, what is the Khatani number, what is the Khasra number, who are the owners, who were, I mean, the position as it existed immediately prior to consolidation. This will be, we can find out from Khatani Ishtimal. Then after the various cases, I mean, the consolidation goes through several stages. Then ultimately the document is prepared, which is called Khatani Pamaish. Now, Khatani Pamaish will tell you this is the new Khevat number, this is the new Khatani number, this is the old Khevat number, this is the old Khatani number, and these are the new Khasra numbers which we now have allotted. Now, to find out in lieu of what has this been allotted, how to tally this, you first find out what is the old Khevat number from the Khatani Pamaish. As I said, Khatani Pamaish will give you both the old Khevat and the new Khevat. New Khevat you have, of course, with you. Then you find see from the Khatani Pamaish as to which is the old Khevat number. And then you take up the Khatani Ishtimal, and against that Khevat number you will find the old Khasra numbers. So this is how you can tally. Rest, I think, for me, to me it looks very easy, but unless it is properly explained. But when I will take up this matter in a separate consolidation section, then I'll give all those exhibits and prove.
I'm sure. I think it was that in the initial starting as well, you did mention that you'll only be addressing to a certain segment of Jamabandi. You'll not be able to.
This is only a basic. In fact, today's session is to the basic Jamabandi, because Jamabandi is also, there are many complex Jamabandis which I will also deal with in the next session. Yes.
Any other move question? To the next question is the Revenue Authority have separated. Okay, so the question is it's majorly about that there's a error in record, and there are 2 separate tasks which have been entered. And
once again, sir,
there are 2 separate tasks has been entered, sir. Tasks.
2 separate.
Tasks.
Tasks. Yes.
So now I'll read the question completely. The revenue authorities have separated and prepared another record. Once the land has been sold by one co-owner to another vendee, but entries had not changed accordingly. So the two separate tucks were entered. At the time of partition, there were two separate tucks of the same land. The new share co-share owner claims the entire mizan of the land, whereas it affects the original rights of the original owner. So what is the remedy? How can we take care of
I understand the question, but there can be, I mean, this question, I don't know exactly what are all the factors involved, but still, basically, I'll tell you, once a co-owner, once a owners, say owner or all the co-owners together, they sell a particular piece, some portion of the land or a share of the land to a vendee, and a partition takes place, then the vendee obviously get his separate tuck. He will get his separate chunk of land, which is called a tuck. Tuck means a separate chunk of land. So he will get his separate chunk of land, and for that chunk of land, he will have his separate khevat number. So the other co-sharers, they will have no right over this separate tuck. But if this separate tuck has been wrongly prepared, for example, as we took the case that one co-sharer sells a specific khasra number to a vendee, as we saw in that Khana Kash sale, and that and the revenue authorities on partition give that particular chunk of land to that vendee, that is wrong. So if something like that has happened, the civil court can always give a declaration that this is incorrect. All the co-sharers have the rights in the entire Mizan Khevat. But separate tuck can be prepared only if the partition has been correctly, legitimately, legally done. If there is error in the partition itself, that a separate chunk could not be given in the partition because it was only a specific khasana number sold by a co-sharer, and that very khasana number has been given without partition only to that one person. Then it will all depend again on the facts of each case. But correction is always possible. As one golden principle that can be kept in mind is that if the error is clerical or typographical, as they say, then fard badar procedure. That is we call fard badar procedure. That can be done by the revenue authorities themselves. But if the error touches the rights of the contested rights of the people, then the only remedy is section 45 of the Land Revenue Act. Civil court, civil suit can be filed and judges can look into this and decide. I think we can now take the last question.
So just two more questions actually. One is about red line. So I think that you already answered, but I'll still read. I'll take the question which is new rather. It's talking about notification for acquisition of land issued. Entries regarding notification of acquisition of land made on the Jamabandi and directed to the alienate. The land is still in the possession of the owner. Compensation not paid for period of 20 years past. Due to the entry in remarks column, owner is unable to sell the land. How this can be deleted in the entry, sir?
For 20 years?
Yes, sir.
No, but that, you're right. I have understood. But the question is, whenever a land acquisition notification is issued, under the Land Acquisition Act itself, it is provided, because offhand I will not be able to tell you, but it is provided that this thing would remain valid for this limited time. And after the expiry of that time, that can be sold. And if he goes to the sub-registrar for sale, he can show that notification and say, this is so much time has elapsed. Now this prohibition has lost all meaning. And still, if it is not done, he can approach the court. But one thing is certain, that the notification of land acquisition does not, for all times to come, will prohibit its alienation. That is only for a limited period, which is specified in the Act and the rules made thereunder. Yes.
So I think the person who asked the question, the member who asked the question, he should be looking if the 20 years has been mentioned over there or not. Because he said that he has not got anything from since 20 years.
But 20 years, I think, is too long a period. For such a long period, obviously, even the entire acquisition would lapse after some 5 years or something. I mean, I'm not read that act recently. There's a change also. But one thing I know as a lawyer, that these things lapse after a specific.
Basically, going back to the notification will be the answer that you can find over there.
Mm.
The last question, and quickly one. How a property situated in the red line can be transferred within the owner when the owner does not have the title deeds?
As I told you earlier, title deed is not the only way to prove title. But the one thing, because it's not that we have title. Now, one question I like to ask: who was the first owner of the land? Did he have a title deed? I mean, the God did not issue any title deed. So when it is only possession. I mean, title has originated in possession. I mean, either somebody can say when God created man, he issued title deeds. Yes, then you can. But here in law, what has happened is the title, it is possession that is the beginning. And long possession creates evidence of title. And at some particular time when Jamabandi was prepared, people who were in long possession, first Jamabandi was, they were recorded as owners. I mean, how were people recorded as owners in the first Jamabandi? They had no title deeds. It was only on the basis of possession.
I think so. That's an advocate inside you is now talking.
So
But
I think
that brings us to the end of the question and answer round,
right.
And I think everyone knows you, sir. If people, I'm sure people will have a lot of questions, but due to the constraint of time, we cannot take more questions now. So I'm sure a lot of people would be calling you up, would be visiting you.
And we can also request them to send their questions an email to the academy. I will personally look into those and answer.
Perfect.
Email to the Chandigarh Judicial Academy.
Sure.
Or even to my personal account, they can email.
Okay, sir. I think
most of them know me.
I'm sure, sir. I'm sure you've been there for 10 years plus.
Yeah.
And considering 10 years is a big, long time.
Yeah.
Considering everyone has to come through Judicial Academy, so everyone can know you. So I think I would request the members who are on this webinar, so when they are sending in the questions pertaining to this webinar, they can put it in the subject line, that subject of today's webinar, interpreting Jamabandi entries.
Yes.
Then they can say the question, because then it will be easier for sir, aapke liye, ki, you can segregate that this is coming from webinar or it's some other email.
And also the person who's sending it, his description, so that I can refer. I will send the question back to him. Answer.
Sure. Certainly, sir. So, sir, I will just give a vote of thanks on your behalf for all the members who have just joined in.
Yes.
Sir. Sir, I would like to thank all the judicial officers across Punjab, Haryana who have joined us today. The Lordship, the Ladyships who have taken out time. And special thanks to Chandigarh Judicial Academy and to DM Lal sir, who has given his precious time, almost 1.5 hours. 1.5 hours is official time, by the way. But sir and I, we were already on this platform for, I think, since quarter to 11. We were setting things up. We were doing. So he's been sitting over here for past 2.5 hours. So it's a really long time. But sir, I really thank you so much on behalf of all the members who have joined this session, on behalf of SCC Online.
And thank you. Thank you, Chetanji, to you also, everybody. Yes.
Sir, we'll now take a leave, and this webinar would also be available to all the members. We'll be sharing the link of this webinar with the Chandigarh Judicial Academy.
Yes.
You can ask the link from Chandigarh Judicial Academy, and you can revisit all these recordings at your disposal. So,
thank you.
That's okay. We'll take a leave. Thank you so much.
Okay, thank you. Right. Okay. Right. ये बंद कर देना.